that he's not gonna sue us for anything.
Yes.
So I didn't see necessary.
I would still recommend in those circumstances. Now, you have to look at things from a sort of fairly practical point of view. Is the claim amount under your deductible? Is the claim amount what you're going to settle for? Is it less than, in terms of this policy, 35,000 dirhams? Is it less than 35,000 dirhams? So if it's less than 35,000 dirhams, why tell your insurance company? You're going to have to pay for that anyway out of your pocket. If it's under your deductible, what's the point? The legal phrase for this is you're self-insured for the amount of your deductible. You're self-insured. So why notify them? So you have to look at it in context. If someone's writing to you about the standard of catering, that clearly is not an issue for your medical malpractice policy. If they're complaining about bed linen being dirty, that's not something you notify your medical malpractice policy. But if it's something that is ambiguous about whether it refers to the standard of care provided, you should err on the side of caution. Now, if they're asking for you to pay them 1,000 dirhams, I can tell you now, there's no point telling an insurance company.
Yeah.
If they're claiming 1,000,000 dirhams, that's something you have to tell your insurance policy. So a certain amount of common sense, I think, have to apply. But leaving aside that for the moment, the obligations are quite clear. The obligations are quite clear.
Thank you.
Okay. Now, there's a couple of warranties given in the policy, and it says this is what you've got to do at all times. You've got to ensure you've got maintained accurate descriptive records. Now, the DHA and the regulator probably make sure that you know all that anyway, and modern professional practice means that you do that anyway. But this policy says you've got to retain your records for 10 years. That's a long time for a busy hospital to maintain records for each patient. And not only retain them, but make sure that you can recall them and get access to them if you need them.
10 years?
So, 10 years. This is for the policy. This is under the policy. Actually, I think the DHA now say 10 years anyway for your files. Yeah. They never used to, but it's 10 years now. Give the underwriter or the duly appointed representative, usually the lawyer, that's what I mean, such information and assistance, statements or depositions as underwriters may require. So basically you've got to cooperate with the lawyers appointed on your behalf. And then assist in the defence of any claim without charge. So you can't bill the underwriter. I've actually seen someone do that. You know, time spent giving a statement, they then sent a bill to the insurance company, which is quite amusing for the insurance lawyers involved.
But if the insurance company,
can we just give you the microphone?
on the part of the legal representation, is it abiding to the facility or the physician to go with the lawyer of the insurance company, or can they assign a separate lawyer?
No, you can appoint any lawyer you wish, but don't expect the underwriter to pay for it.
For the lawyer,
Yeah.
unless if the policy covers.
Well, no. A lot of the times, if there's a good relationship between the underwriter and the insured, I've seen this quite a few times, and the insured makes a particular request for a particular lawyer, a good underwriter will be flexible and take into account that request. That's a commercial relationship thing. I've seen it happen many times, and the underwriter sort of bends. Now, what they will do, though, is make sure that the lawyer is competent and has experience in defending these types of cases. But and the fees are within the scale that the underwriter would expect to pay. I mean, appointing me, I'm modestly invoiced. You couldn't go to a very, very expensive lawyer who charges 5,000 dirhams an hour. They say, no, you have to pay for that yourself. Yes. So remember, this doesn't stop you doing anything you want. This means if you want the underwriters to pay for it, you've got to do this. Otherwise, they can say, well, if you decide to go that way, we are not covering you or not covering that expense. But you can still do it. Okay, this is another important aspect. I think we all know this, but it says the assured shall not disclose to any person the terms of the policy, so it's private and confidential. No liability shall be admitted. No arrangement, offer, promise or payment shall be made, or costly expense incurred by the insured without the written consent of the underwriters. Which basically means if you're going to settle it, you're going to settle a claim, if you're going to make an offer to settle, you have to have the underwriter's prior written approval. And that makes sense, I think. If you're going to bind the insurance company, if you want to bind them, then it makes sense that they have the underwriter's approval to do so. I think that's sensible. In your particular case, man, in your particular case, for a small amount, you decided to become self-insured for that claim. You didn't notify your underwriter, it's within the deductible. That doesn't really apply. Because you're not going to make a claim under the policy.
Is this clause only under this contract? Because like I didn't see it in like we're talking about that they have to agree under any circumstance with
if you're going to make a claim under the policy, yes. If you're not going to make a claim under the policy, you do what you want.
Yeah, no, I meant under the policy.
Yes, yes.
Okay.
Every now and again, you get here, number 6, any dispute concerning the policy wording, subject here to the laws of the United Kingdom. It just shows you that most of these policies are actually written by the reinsurers. Is everyone familiar with the reinsurance? Yeah. Basically, insurance companies in the UAE, they buy insurance. And they buy it somewhere else that has an experience, an underwriting experience of the particular risk. So for example, London is the centre of insurance, modern insurance. So a lot of these claims go into London, which is why you see, it's actually a bit of a misnomer because there's no such thing as the laws of the United Kingdom. Because there's 3 separate legal systems in the United Kingdom. So it should be the laws of England and Wales, actually. But, later on, there's an endorsement to this policy, which makes it subject to the laws of the United Arab Emirates, which varies the exclusion. But this is for lawyers, every lawyer here will know that every contract should have a choice of law and choice of jurisdiction. Every contract should have one. So there's an endorsement, medical defence organisation clause, so that's the jurisdiction. It changes the wording to the United Arab Emirates. Okay, now then, can I ask you to look at your packet of documents, and you'll find the scenario and the letters. So in your packet you've got your scenario, it's in English and Arabic. And there's a couple of letters. Now if you want, I can quickly run through it. Or you could maybe just spend a few minutes just having a wee read at it. It's only a couple of pages. So it's the document entitled Medical Liability Insurance Related Problems and Damages in Medical Malpractice Lawsuits Workshop Scenario. So this is the workshop scenario. The last page of the document is blank, so if you want to just make some notes about dates, you can just use that. It's not in that, that's the slides, it's in a separate piece of paper.
This one?
Yeah, that's the one.
I found it. Found it? Okay.
Yes.
You found it?
So this is this workshop scenario. No. You want this? That later? That later and that. That's it. You got it? Okay. If anyone doesn't have a scenario, if you put your hand up, I'll come and find it for you. You found it, yeah?
Yeah, this one.
That's the one.